Why is that habit?
My lord,
It could have circulated yesterday. Every time we tell that please assist us. If you don't want to do, we are liberal in giving adjournment. Please tell us in advance. We list about 15, 20 cases so that we hope we do it. And then you take an adjournment. You wait your turn, and when the turn comes, then take an adjournment.
my lord. May I please, your lordship? Sir, beg to mention item number 16.
No. If it's not circulated earlier, we are not adjourning. Well, let the matter reach.
So we have submitted the adjournment.
We have submitted.
Lordship. Because my
Just a moment.
father-in-law of my.
No, if you have submitted, then we'll adjourn it.
Sure.
Don't worry. Yes. Yes. Item number
Item number 16, lordship.
16. Yes.
I am for the respondent number 3 on behalf of SG Borua. Lordship, petitioner side is also.
Once adjournment slip is there, we are adjourning it.
Lordship.
Both sides are represented on the prayer made by Learned Council for respondent number
3, lordship. On behalf of SG Borua B Borua.
Council for respondent number 3. The matter stands adjourned today. List after.
Lordship, I need it after 28th September because father-in-law of my seniors expired. Lordship. I need it after 28th September. Lordship.
Can it be after vacation on 24th of September?
It goes after vacation now.
24th of October, can it be? 24th October.
List in the week commencing 28/10/2024.
24/10, can it be? 24/10. It's a hearing day.
24/10.
Yes.
We're making it 29th.
Much obliged, lordship.
Much obliged.
29/10.
Much obliged.
Much obliged.
Yes.
My please, your lordship. Lordship, adjournment request has been submitted for item number 12 to 15, your lordship.
Yes.
Madam.
Both sides are represented on the prayer made by Learned Council for the petitioner. The matter stands adjourned today. Just after 2 weeks.
2 weeks, your lordship.
Okay.
Okay, your lordship.
That means, I have filed an IM in pending case. Bail was granted to him, so that he has been arrested.
Yes.
But
Supply list item 17 for motion.
Mr. Mahmood, you yesterday told us that you gave us citation. Then citation is not available. When I asked him, then he says that the citation is not given.
No, my lord, printed
you-
copies
you
was
see-
not given, but
You see,
citation is given.
we asked you, citation was not given. When
No.
yesterday I asked my court master, then he said that it's not given.
No, here we have given, madam.
No, he was there yesterday. When he asked him, he said that it's not there.
But he may forget this, but we have given the site, but copies were not furnished.
No, we did not ask for copies. We asked for citation only.
Citation is given, madam, yesterday. Perhaps it may
Yesterday it's not
be,
given.
it may be missing.
It's not given. Because I personally checked it up. It's not given. Yes, which citation you want to rely on?
First, my lord, I want to draw your lordship attention. That is the Foreigners Tribunal Order 2013. Last E, issuing a warrant of arrest.
2013?
Yes.
What?
The Foreigners Tribunal's Amendment Order 2013. If it is not there, I have extra page heading. Huh? Oh, 138. It is there. Do it about it. Page 138. Operative portion, page 144. Operative portion 144. I have reproduced it. 138 and operative portion, page 144. E. Issuing a warrant of arrest against the proceeding if he or she fails to appear before it. An expedited order lordship has been set aside by so many judgments are there. I have given the citation 2021 edition. I have given the copies also. 2021 2 GLT 568. I just asked some. Also, oh, also. Of course, citation only this one. Person available. Cycle message here. येते असं नाही की येते आता लिखा सायकल My lord, 2021 2 JLT 568 para 812 67. This, my lord, my lord Justice, Honorable Justice Soikia was also part of this bench, my lord. So the expedited order was set aside. It was by my Lord Justice Koteshwar Singh and my Lord Justice Soumitra Soikia. So, paragraph, my Lord, first kindly see, para 8 kindly see first. For the aforesaid reasons, we are of the view that the expert opinion of the tribunal will not be applicable to the petitioner. However, since in view of the confusions, misunderstandings, and inconveniences which may be caused to the petitioner on account of the similarity of the same of the petitioner's husband and address, and as the petitioner herself has voluntarily to approach the learned foreigners tribunals, Punitpur, Tezpur, to clarify the matter. The petitioner may approach the tribunal for necessary clarification. Then para 12, my lord. As a corollary, if the proceeding who has been proceeded on the ground that she is an entrant during the period of 1166 and before 25/3/1971 does not appear before the tribunal, and the tribunal proceeds against him her ex parte in failure to discharge the honors placed under Section 9 of the Citizenship Act 1955, the proceeding may be liable to be declared as a foreigner who entered during the aforesaid period and not a foreigner who entered post 25/3/1971. Therefore, a proceeding cannot be placed at a more disadvantageous position than being charged of. Accordingly, the foreigners tribunals will reconsider the matter and pass appropriate order in FT case number so and so. On this ground alone, irrespective of the identity of the proceeding, the impugned opinion of the tribunal dated so and so, passed in FT case number so cannot be sustained and accordingly set aside. Then, Lordship, there are also now, para 18, Lordship, may kindly see, para 18. Further, as provided under Order 3.1 of the 1964 order, the tribunal is to serve notice on the person to whom the question relates to, and the tribunal is to give its opinion in order of reference. Thus, if the reference, as mentioned in the notice, is that the proceeding is an entrant in this country during the period 1166 and before 25/3/71, as per the reference made by the authorities, the foreigners tribunal has to consider the reference with vis-a-vis the said period and cannot consider and give any opinion order to the effect that proceeding is an entrant after 25/3/71 for reason that it was never the case of the authority that the proceeding is an entrant of post of 25/3/71. Of course, this is a different thing. Only our submission is this: there was an ex parte order, and the petitioner filed petition before this Honorable High Court. Honorable High Court set the order and gave a chance to the proceeding to prove her citizenship. Here, my lord, there is also some other things are here. The service of notice. Service of notice. Well, if the Jarikara goes to the house of the person and the person does not take, there are some proceedings, there are some procedure that is not followed. Only a learned tribunal said that after receiving notice, she did not come. But Jarikara was not examined, and whether there was any attempt to take the evidence of the nearby persons or the male member of the present petitioner, nothing is there. So Muslim Mondo's case is violated.
Yes, Mr. Sharma.
Yeah.
We intend to call for the notice at this stage, the records.
Record.
We call for the records.
I will make call for records, but I may be protected because
Yes.
I did not receive notice.
All right, heard. Mr. Remy Mahmood, learned counsel to the petitioner, Mr. G. Sharma for respondent number 3 and respondent number 6. And who else? Mr. P. Sharma for respondent number 5. Mr. Kuli for respondent number 2. Anyone for union? Stop. Petitioner is aggrieved by the order dated 21/7/2023, passed in FT 9th within bracket BPT bracket close case number 572 of 2017, passed by the learned member Foreigners Tribunal 9th Borpeta. By the said order, which was passed ex parte, the petitioner, the reference was answered in affirmative and in favor of the state, and the petitioner was declared to be a foreigner of post 1971 stream as per the provision of section 6 capital A of the Citizenship Act 1955 as amended. Stop. Learned counsel for the petitioner submits that the notice as required by the tribunal was never served on the petitioner, and consequently the petitioner could not appear and contest the matter. Where the court would like to examine the tribunal records before proceeding further in the matter. Stop registry to requisition the records connecting to FT 9th BPT case number 572 of 2017 from the Foreigners Tribunal 9th Borpeta. Stop. Meanwhile, petitioner will appear before SP Border Borpeta within 10 days from today. And if a bail bond of 5,000 is submitted before the SP, petitioner will be allowed to remain on bail and shall not be deported out of the country without leave of the court. Stop. When the petitioner appears before the SP Borpeta, the biometrics of iris of both the eyes, the fingerprints, and the particulars with regard to the contact details and address of the petitioner be recorded. Let the matter be listed after after the receipt of the tribunal records. Extra copies on the respective councils be furnished within 1 week from today.
Highly obliged.
List according.
Otherwise, Lordship, there is a procedure for setting aside the ex parte order, Lordship.
We want the
Order
records
is-
first.
Yes, Lordship.
Let us have the records.
Sir. Oh,
Yes.
Item-
switch off phone delete.
I thought I had called.
Item 18, item 1 of daily list.
May I? এটা দিদি আছে। এটা দিদি বেলেগ বেলেগ থাকিব, পিন মাৰিব নালাগে।
No, no.
Here, my lord, conviction is 302, read with 34 IPC. Yes, sir. I have prepared, my lord, dates, list of dates and synopsis.
Indicated in the list. Indicated in the list. What's this?
Yes.
Here, my lord, I have prepared list of date, synopsis, and summary of the witnesses,
Yes.
my submission, and I am relying case law I have given to your lordship. So, my lord, I am going to the, my lord, directly to the paper book. Here, page 1. Page 1, your lordship will find column 3. Occurrence of offense day 25/5/14 at 9:30 p.m. and information received at 26/5/14 at 10 p.m. more than 24 hours after the incident matter. Then your lordship kindly come to the page 2. column 8. Page 2, column 8. I've got you. A reason for delay in reporting the complaint informant backend. I've got you. Then page 3, my lord. Column 11. Inquest report ED case number, if any, no. Backend. There is no inquest at all in this case. Now page 4, this is the FIR on the basis of which, my lord, the law was set into motion. May I read now?
Yes.
Humble submission is that a few days ago, the above named accused person, accompanied by the Gauda of such and such, came to our house and said that they would buy a plot of land. And they forcefully obtained our signature and took possession of 2 katas of land. Around 9:30 p.m. on 25/5/14, the aforesaid accused person, armed with dao and axes, came to our house, dragged my husband out of our house, felled him on the ground, and killed him by assaulting him with axe. When I raised a hue and cry, they showed me a dao, pressed my neck, and assaulted me. When my younger daughter, Harila Gaur, begged the accused person by falling on their legs, they said that they had come there after obtaining permission from Gauda. When they tried to kill my daughter, she fled from there. Everything will be evident in the course of investigation. So informant is PW1. Page 7, my lord, charge frame order 30234, charges frame. Under 2 head, that is first is 30234 and head 2 is 44834. Thereafter cases, this is committal order. Order of framing charge is page 11. Now page 12. Married.
Yes.
PW1, Bhagavati Gaur. I am the informant of this case. I have lost the case against Anil Gaur, Kamala Gaur, Joy Singh Gaur, Madan Panika. Today I have seen Anil Gaur and Madan Panika in the court. Deceased Tonkeshwar Gaur was my husband. At 9 p.m. on 25/9/19, that may be 14, the incident took place. At that time, I was at home along with my husband.
Yes, ma'am.
It is 14, it should be 14. That typographical mistake. At that time, I was at home along with my husband and 2 daughters. In the morning, on the day of incident, a quarrel took place between my husband and the accused person. Anil Gaur is my brother-in-law. Joy Singh is the son of Anil Gaur, and Kamala Gaur is the wife of Anil Gaur. Since my brother-in-law Anil intended to give his daughter in marriage, he sold his portion of land and then my husband put his signature. But they sold our part of land. In the night of incident, Anil armed with rod, Madan armed with axe. Anil and Madan are the appellant in this case, madam. They are. Kamala armed with dao and Joy Singh armed with stick came. Madan assaulted on the head of my husband with an axe. Joy Singh inserted the stick inside the mouth of my husband. Kamala dealt dao blow on his neck. When I went to rescue my husband, Madan asked me to go away and said that he had taken permission from the Gaubula to assault my husband. Out of fear, I fled to the house of Keria and I became senseless there. My daughter also took shelter in the house of Keria. In the morning, returning home, I found my husband lying dead in the courtyard. After that, I, along with my two daughters, went to PS and lodged an Azhar with the PS. Exhibit 1 is the Azhar and I have lodged Exhibit 1 is my signature. One person, Ali by name, wrote the Azhar for me as per my words. Police took the dead body of my husband to the hospital and got the postmortem done there. Exhibit 2 is the statement I made before magistrate under 164. 2 is my signature. Anil cross. Anil Gaur's house is situated near to our house. There are about 20-25 houses near our house. One can get the house of Keria after crossing 2 houses from our house. Just after the incident, I, along with my two daughters, went to the house of Keria. The land over which quarrel took place is situated about 1 kilometer away from our house. That land belonged to my father-in-law and he had around 8 bighas of land. My father-in-law had 3 sons. The eldest one had died earlier. I lodged an Azhar with the PS over selling of our land by Anil Gaur. After the death of my husband, I lodged an Azhar against Anil Gaur over the matter of selling of land. The land was not sold through a deed, but forcibly took the signature of my husband in order to sell land. I do not know as to where Anil had gone after taking the signature of my husband. Anil sold our land to a person of Muslim community. When the person of Muslim community started tilling the land, we asked them about the matter and then he replied that Anil had sold that land to him. Both the brothers quarreled over the matter of land. My husband had the habit of drinking. It is not a fact that on the day of incident, my husband was raising a ruckus after consuming liquor. I stated before police that at 9 p.m. on 25/5/14, it may be again type mistake, my husband returned home in intoxicated state. It is not a fact that I stated before police that at that time, my daughter were sleeping. My younger daughter was sleeping, but elder was with me. I did not state before police that when my husband raised a hue and cry, saying that Anil Gaur had grabbed our land, the accused person came armed with dao, axe, etc. It is not a fact that I stated before police that noticing them coming to our house, I got panic and then walking my two daughter up, I left the house of Keria. I left for the house of Keria. It is not a fact that I did not state before police that Madan, Anil, Kamala and Joy Singh assaulted my husband with axe, rod, dao, and stick, respectively. It is not a fact that I did not get the above fact written in Exhibit 1 Azhar. It is not a fact that the quarrel did not take place at our house. It is not a fact that the accused person did not come to our house armed with dao, stick, and axe. It is not a fact that my husband falsely implicated the accused person in the case loss of our land. At the time of incident, electric light was on in our house. Just after my husband had been assaulted, I fled away from there when they said that they would kill me too. It is not a fact that I did not witness the incident. All the facts that I stated before magistrate are true. The facts I stated before police are true. It is not I did not see the paper on which my husband put his signature. When Madan and Ram Singh came at first, I persuaded them. Later, rest two accused persons came and assaulted my husband. Our house is on one side of the road and their house is on the opposite side. We had no cordial relation with Madan. Madan threatened to kill my husband earlier. It is not a fact that I stated before police that I had prepared food for my husband. At first, I ran away from there in fear. My daughter went 16 PW2 Harila Road. The informant is my mother. I know accused Anil and Madan. Anil is my uncle. Another accused is our co-villager. I have not seen accused Joy Singh and Kamala Joy Singh. Kamala Joy Singh is my brother, that is the son of my uncle, and Kamala is my aunt. Deceased Tonkeshwar is my father. Around 9 p.m. on 25/5/14, the incident took place. At that time, my mother, father, younger sister, and I were present. Then we were talking about landed property. At that time, the four accused persons entered into our house and abused my father. My father said that as he had no son, why he should sell his land. Altercation took place over that matter. After that, Madan said that he was going to the house of the village headman. After 3-4 minutes, Madan returned there and said that he had got permission to assault my father. Then Madan dealt an axe blow on the head of my father. Anil beat my father with a rod. Joy Singh inserted a stick inside the mouth of my father, and Kamala dealt dao blow on my father. When my mother went to rescue my father, Joy Singh assaulted my mother also. Out of fear, my mother went to the house of Keria. My younger sister and I were at our house itself. I gave water to my father. Then my father asked me as to where my mother had gone. I saw blood coming out from the mouth of my father, and my father became silent. Thereafter, I went to the house of Keria, taking along my younger sister. We spent the night in the house of Keria. On the following morning, we came to see our father and found our father lying dead in the courtyard. Then I accompanied my mother to the police station, and mother lodged an ejar with the PS. On being lodged the ejar, police came and took away the dead body of my father to the hospital. On 28th day of month, I gave my statement before the magistrate. Exhibit 3 is the statement that I gave before the magistrate. 3-1, 3-2, and 3-3 are my signature. Gross. At the time of the incident, I had passed class 8. If one goes to the house of village headman from our house by road, it will take 5 minutes. And if he takes a shortcut, it will take 2-3 minutes. On the day of incident, my father did not return home in intoxicated state. On that day, father returned home around 4 p.m. There are houses of 4-5 other people near our house. Except Panika, others are relative of the accused person. On hearing hue and cry, none of our neighbors came there. My younger sister and I did not go to the house of Keria. It is not a fact that I did not state before police that the accused person has assaulted my father with axe, dao and stick. Police did not record my statement. I did not state before police that at the time of incident, I was sleeping in my house after having my meal. I did not state before police that I took shelter in the house of Ramgarh. About 1 hour after the incident, leaving our father, my younger sister and I went to the house of Keria. I told Keria and their family member about the assault on my father, and I also told that blood was coming out from the mouth of my father. They did not take any step in order to provide treatment to my father. 1 month before the incident, my uncle, accompanied by the village headman, came and obtained the signature of my father. The name of the village headman is Lolit. Uncle told my father that he would sell his land. Therefore, he required the signature of my father. But uncle sold our land. We came to know about it when the person of Muslim community was stealing on our land. On being asked, the person replied that our uncle had sold the land to him. Returning home, when father asked my uncle about the same, the quarrel took place over the matter. It is not a fact that the accused person did not enter into our house armed with dao, stick, axe, and assaulted our father. It is not a fact that the accused person did not assault my father to that. It is not a fact that I have falsely implicated the accused person. My father was dragged to the courtyard from inside the house and was assaulted there itself. We were asked not to raise any hue and cry. Therefore, we did not do the same. It is not a fact that the accused person did not assault my father. They also assaulted my mother when she went to rescue my father. It is not a fact that I have deposed falsely. So, basically, evidence of 1 and 2 has been relied upon. Mother and daughter. Daughter and wife of the deceased. Their evidence is after assault was made by the accused, they went to the house of
With this
Keria.
evidence, we were thinking why we should not give you a notice that why not capital punishment.
Yes, it is a clear case of malad acquittal. Your lordship,
Acquittal, no, I am saying capital.
yes, your lordship views are different, but while I am submitting on behalf of the appellant, and I will try to substantiate my argument, my lord. Your lordship, consider first I have already pointed out that there is a delay of more than 24 hours. Number one, there is no mention of cause of delay. There is no inquest. There is the 3 thing I have already 3 points. Now the 2 evidence, 2 deposition of the 2 witnesses. Their case is that they witnesses the incident of assault by the accused. 5 persons have been named. After assault was made, they left to the house of Keria and stayed entire whole night there at the house of Keria. They are not the my lord. If they are the
This girl was 12 years old. Mother had left.
both. Subsequently,
But
first
this-
mother left.
This girl is 12 years old.
Yes, she was class 8. When
They are afraid.
he was in class 8.
I'm not on the class. I'm on the age. At the date of incident, she was 12 years old.
Yes, 12 years.
So at 12 years old, how the child will react, we don't know.
But mother is there. They,
See, they,
I
they
will
live,
submit my.
they live in a society where nobody came, even after the person is dead. Nobody came to see the dead body. Nobody comes from the neighbor. They go and tell the neighbor, nobody comes. What will they do?
This is quite natural that nobody come. There is a already in the evidence that they are not with a good relation with the neighbors. That is there. But this is not my point of argument. My point of argument is that when the husband, my husband, has been assaulted, blood oozing out, I left him on the courtyard and went to the house of a co-villager, which is at least after 2-3 houses. And I stayed a whole night there. This is unnatural, quite unnatural. I will try to substantiate my argument, buttressing upon 3 case laws.
You'll have
This
to,
is
you'll
quite
have to-
unnatural.
you'll have
That-
to refer to deposition saying that there is nothing there except a bamboo grove in that area where the incident took place. So it's not a thickly populated area, appears to be.
It is there.
Incident occurred
This is
at
not
night.
my point of argument. My point of argument is that,
No, is it so bad?
yes,
Somebody wants to save his life. The wife saw the assault. She wants to save her life and she did not come. It is
Yes.
so unnatural.
I will point out, my lord, at the later stage of my submission, my lord. The evidence appears that 1 and 2, that both of them sustain injury. Both of them sustain injury. This is your lordship kindly
In
note.
in the medical report, both suffered simple injuries.
And the age of injury, my lord has already gone through. Age of injury. They were examined on 26 at around 8:30. After lodgement of FIR. FIR was lodged at 10. Thereafter, and doctor said the age of injury is only 6 hours. That means their injury found on their person is
Can be-
much after the incident.
You look at look at the medical books. The age, you see that age is only an estimation. It can't be perfect.
That is true, madam. But 6 hours and the incident when they examined, at least 26 to 27 hours before incident happened. Medical evidence may be vary. 6 hours can be 10 hours.
So you want to say that the young girl beat up her mother, the mother beat up the 12-year child.
No,
Then
that may be another incident. How? And I will point out the doctor's what doctor say.
shows that.
Yes. Now PW3, Ruplal Guala.
Oh, they are not eyewitness.
They are
written
not
also. We can omit them. 2, 3, 4, 5, we just omit them.
Yes.
All these witnesses, 6 and all, they're not relevant.
6 also not relevant.
6, 7, same thing. These
Same
people are all, later on they saw the dead body. 8.
PW5, he's been named in the FIR. With his permission, the village admin, his permission, they came up. PW5 is like.
This is only sad that he is not a co-accused. Abatement, he would have been, he should have been accused.
His line of argument may be different. He is
No,
appearing.
he's an amicus curiae. He has a right to.
Well, definitely.
But
My line of argument is that the evidence relied upon by the trial court is completely unnatural and not trustee of my lord credence.
I would say sterling quality. PW 1 and 2 appears to be sterling quality witness.
I'll try my level best to satisfy your lordship, my lord, with the case law, my lord.
Yes.
8, Binoy Gaur. He is also, my lord. I know the complaint, I know the accused.
No, these are not relevant.
Now my
9 is the.
doctor evidence, my lord. PW9. Here is my argument there. On 26/5/14, I was on duty as senior medical and health officer. 1. On that day, I did postmortem on the dead body. That means, Your Lordship, kindly note this point. 26. Postmortem was conducted. That means after lodgement of the FIR. After within 24 hours or 24 or 25 hours in between, the postmortem was conducted. External appearance, multiple liner abrasion, such and such, thorax, sternum fractured, blood in pleural cavity, injured, collapse, abdomen, blood present, scalp, hematoma in occipital region, fracture seen at sternum. More detailed description of injury or disease. All injuries are antemortem in nature. Approximate time of injury within 24 hours. Time of death. This is important. This is my point. Time of death. Over 2 days, 48 hours. As sign of putrefaction on body started. Body was started to decompose. That means after 24, as per the prosecution, as per the case projected by the prosecution, the postmortem was conducted within 24 to 25 hours. Am I clear, Malik? And doctor's finding is that the body was about to decompose 48 hours. This is my first point of argument. That means my humble submission is that that part of evidence itself, my lord, proved that the entire story of the prosecution has been projected as actually the person was died at least 24 hours before the projected incident. And the other evidence, my lord, PW to your lordship, I have already said 6 hours. 26, 5:14, I was on DT, examine Bhagyavati, this is PW1, less than 6 hours, caused by blunt object.
You see, that doesn't change. We'll tell you why. First of all, as per the medical documents available, putrefaction of a dead body starts within an hour of death. It is 24 hours. The putrefaction is can be there and complete. The reason is, I'm saying so with some authority before me. Putrefaction begins within an hour of death, but peak activity of microbe occurs within 24 hours time frame. As the activity of the bacteria increases, the amount of putrefaction gases produced rises.
It is like that, my lord.
No. You see, we must take into account everything.
Yes.
The medical evidence.
I am trying to answer your lordship query, my lord.
Hmm.
Supposing a candle, my lord, the moment it is ignited, it starts burning. But it will take at least 1 hour or 2 to completely burn.
You don't know.
Here, doctor's categorical finding is that the 48 hours, at least 2 days, 48 hours,
Hmm.
because the stage of decomposition, my lord, stage of putrefaction. Your lordship is correct, my lord. The putrefaction start within 1 hour. Your lordship is correct. But the stage of putrefaction, it is the finding of the doctor.
Oh, for that one, in medical terms, we'll have to go to autolysis and then find out.
They
These
are in
things-
appeal, my lord.
These things are.
The appellate court has the jurisdiction to examine appellate court, my lord.
You have to support this
Yes.
with some authority to
Yes.
say that putrefaction will not start if within 24 hours from death.
Yeah, that I have not denied.
Ah.
That I have not denied.
Right.
That I have
So
given an
if
example,
it's-
my lord.
if it starts within 1 hour, 2 hour, half an
Yeah.
hour, 3 hours,
Stage, my lord. That is important. Stage of
Even in
putrefaction.
putrefaction, Mr. Uddin, even in putrefaction, we have various stages.
Yes.
this is
Out of
not
the
indicated.
stages, there may be some stages where the putrefaction, as per the parameters prescribed, can be said to occur after 4 days. So it's not necessary. It's not necessary that when somebody gives an opinion, you see, opinion is only an opinion. Putrefaction or not, but there is a corpus delicti. There is a dead body available. The person who died is the husband and the father of the PW1 and 2. They gave a statement. Now, offer the ocular evidence and the medical evidence can override the ocular evidence. That is something we'll
No,
Exactly.
cannot. But the question is that whether the ocular evidence is cogent or reliable. And my argument is that, my lord, what I have said, your lordship is correct, but it is, the time is May, in the month of May. In the month of May, and if had it been in January, your lordship said after 5 days, or this is also weather condition that
we
vary.
don't know. This is something which is not available in the evidence. We can't go
Right.
into those things.
We can presume, my lord, that presumption can be drawn from here that after 48 hours, what will be the condition of a dead body? After 24 hours, what will be the condition of the dead body? So my humble submission on that point is that this particular point, this doctor evidence remain because it is out and out against the prosecution case. And prosecution did not declare this doctor hostile. This because one and your lordship is well aware that when a witness deposed against the case of the prosecution and he is not declared hostile, prosecution is bound to accept his evidence. This is the law, Mike. This part out and out against the prosecution case, Mike. And this witness has not been declared hostile. Therefore, we will get the my lord benefit, my lord. Because two views, and your lordship also well aware that when view favoring the accused, that should be preferred. So, my lord, I have this much point, and
The-
now I will, my lord.
The status of these people is revealed by PW11. The status
Yes,
of these
and
people,
IO has confirmed the contradiction, how they improved their case.
PW11 categorically says he knew it and did not go because this man consumes liquor and creates ruckus. Therefore, he says that we did not go.
Your lordship kindly peruse the page 38, man,
38.
cross part of the IO.
Yes.
At about 6:30 AM on 26/5/14, the complainant orally informed me about the incident. I did not obtain her signature. The written Azhar was lost at about 10 PM on the following day of the incident. Subsequent to the receipt of the Azhar, the Samaguri OC asked me to investigate the case. Before lodging the Azhar, the OC Samaguri did not give me written permission to investigate the case. The place of occurrence is about 10 kilometers away from Samaguri PS. I went to the place of occurrence by motorbike and I took about 15-20 minutes to reach the place of occurrence. Thereafter, about 7-8 houses near the place of occurrence, I met Gauguda at the place of occurrence. The name of Gauguda is Lalit Pinjuar. The house of witness Naresh Gwala is at Shialmari. House of witness Radhesham Gaud is also a Shialmati. All the witnesses are from Shialmati. The complainant told that her husband came home last night under influence of alcohol. But in her deposition, she has not said that she was in the house with two daughters and her two daughters had taken meal. The father told that her husband was preparing roti chapati and Anil Gaud came with an axe to assault her husband and assaulted him. That she along with her two daughters took shelter in the house of Keriaram for the night, and that in the following morning she came and found her husband lying dead. The house of Kartikram is about half furlong away from the house of complainant. Witness Hatila stated to me that she was sleeping after taking meal in the night. That having heard a hue and cry, she came out and saw Madan Panika, Bhula Panika, and Anil Gaud with axe in their hands, coming to assault. That out of fear, her mother entered the house, that they assaulted her father. That when the accused person attempted to assault her, she fled away. That blood come out through the mouth of her father when she was assaulted, and that on the following day she found her father lying dead. I collected the two seized articles from the place of occurrence. There had been frequent quarrel between the parties with regard to the landed properties. Now, my lord, seizure list is important. Seizure list, go to see. Seizure list, page 68. Page 68. A lathi made from betel nut tree. The Lashu got it made.
68,
6-8.
yes.
A lathi made from betel nut tree and a spear made of coil rod measuring 4 feet. But the evidence is that assaulted by axe, thou, nothing seized. Weapon of assault has not been seized. And 164 statement of the daughter murder at page 71. First, your lordship kindly peruse the 164 statement, page 66. Informant. Categorical, my lord. Madan Panika brought an axe. Anil brought an iron rod. Kamala Gaud was armed with dao. Joy Singh had a lathi. After entering our house, Madan Panika hacked my husband on his head with axe. Anil started to assault my husband with rod. Joy Singh attacked my husband by inserting lathi. After coming inside our house, the accused person dragged my husband out from his room to courtyard. One of them ran to the Gabula to obtain permission from him to assault my husband. When they assaulted my husband with axe, I immediately went forward to save him, but they felled a bamboo fencing belonging to Madan Panika upon me. Entire incident took place in front of me. Fearing that they might kill me too, I ran away from there and reached Keria's house where I became unconscious and fell down. at that time of occurrence, beside my husband, my daughter Harila Gaur was also present there. They assaulted her too. And page 71, daughter's statement under 164. Around 9:30 on 25, my parents were talking about our landed property. I was in the other room. At that time, Madan Panika, Anil Gaur, Joy Singh Gaur, and Kamala Gaur came. They were armed with dao, lati, and axe. They came to our house, and after asking my father as to why he had been scolding them, dragged him out to the courtyard. Joy Singh and Anil kept holding my father. Madan went running to the Gaubula's house, saying that he would obtain permission from the Gaubula. He returned after 2-3 minutes and said that he had Gaubula's permission to assault my father. Whereupon Joy Singh assaulted my father in the leg with dao. Kamala Gaur was holding my mother by placing a dao on her neck. Then Madan's mother came and took Kamala away from there. After that, Joy Singh held a bamboo fencing upon me. Then Madan assaulted my father on his head with an axe and also gave a cut blow on his chest. Anil assaulted my father with a rod. He inserted the rod in my father's mouth. Later, Joy Singh assaulted my father and inserted a bamboo in his house. After that, they went away. After the fight was over, my mother ran away to Keria's house and became unconscious there and fell down. Then I came to my father and called him. He asked, "Where is your mother?" Blood was coming from my father's mouth. Then he stopped talking. Then I went Keria's house talking along with my younger sister Jaimati and stayed there for the night. When I returned home in the morning, I saw that my father was lying dead. So, consistently they say, thou and X. These two instruments was not seized. Now on the, I have given the my lord summary of the evidence of lawyer exam. Here my submission is that, my lord. PW 1 and 2 L is the incident took place at around 9 p.m. to 9:30 p.m. on 25/5/14. As per PW 12, IO PW 1 lost verbal information at 6:20 a.m. on 26/5/14, on which basis Shivastan Police Outpost GDNT was made. The FIR was lost after a delay of 9 hours, whereas the Shivastan Police Outpost is situated at a distance of only 2-3 kilometers, but no explanation to the cause of delay at all given. There is sufficient improvement on the version of PW 1 and 2. None,
We have read the cross-examination of the IO.
yes.
This is a case where he should be prosecuted by the state. There should be a departmental proceeding against this police, the IO,
Right.
by the state. Look at the first line of his cross-examination. Look at that. He not only says he is not only exposed himself, but his statement is false. On oath, he is saying a false statement.
On 26/5/14, I was serving as IC
No,
at
cross. First line of cross.
6:30 a.m. on 26/14. The complaint orally informed me
Yes.
about the incident.
So he did not reduce it into a GD entry.
Hmm.
That is one. Now, in the later part, he says, after that, he says that he registered the FIR on the next day night. It's a false statement because on 26th, the FIR is lost at
Yeah.
10 p.m. So there is an explanation. The police has shown his culpability.
Unnatural my third point is unnatural behavior of the witnesses, my lord. Another of the FIR and the magistrate recorded statement, the author of the FIR and the magistrate recorded the statement of PW 1 and 2 under 166 not examined as witnesses. The FIR and the statement recorded under 164 CRPC not proved as required under law. Enmity between the parties is admitted. Land dispute between the parties is an admitted fact. Deceased family had no good relation with the accused family. The deceased is a habituated drinker and regularly create hue and cry consuming liquor. Therefore, no people of the locality went to the house of the deceased at the time of occurrence, despite hearing hue and cry.
No, she's there.
PW,
According to PW 5,
Yeah, just a moment.
she's Harila. From the statement of PW 1.
Mhm.
My lord, may I kindly peruse PW5. Just one line I am referring. PW5 page 23. Only one line.
Yes.
1, 2, 3, 4, fourth line. Man. Tonkeshwar and saw his dead body lying on the courtyard of his house. Then the next line. I saw an injury on the head of the dead body, which seemed to have been caused with the handle of an axe. I got it.
How will you know that it was with the handle of an axe?
Yes. We come to know it from page 74. My lord, for a moment, kindly page 74.
No, he can say,
Yes,
he is not a witness. He's not an eyewitness.
no.
He has not actually gone to the place of occurrence. Or has he gone? He has gone.
Yes.
He has gone to the place of occurrence.
And he's seen the dead body.
He's seen the dead body.
And he said the one on the head appears to have been caused by a handle. That means
It is not his deposition that there was an axe or a handle lying near the dead body. There's no deposition to that effect.
Mr. Uddin, Mr.
Wanted
Uddin,
to-
What I'm trying to say
Mr. Uddin,
is,
you see, please understand my brother.
My lord.
he says something, he can't give an opinion. He's not an expert. It's not that he has seen about 20 such murders and then he can identify the injury by the weapon.
He is not
So-
giving,
So
he,
therefore, it's only an opinion.
he has
that-
not given his opinion, my lord. He
That opinion is,
give an opinion different thing. He says what he seen. He said
No,
that
no,
it
no.
appears to have been caused by a blunt.
so appears.
That's what I'm saying. Is the deposition is that no, it is not a knife or an axe, but a handle or stick. How can you say it is by the
While
handle
you
of
are
an
referring
axe?
PW5, your lordship kindly for a moment page 74, postmortem report.
It only says lacerated injury. Now you see, when you go to any medical document, medical book, lacerated injury would normally come when he's assaulted with a blunt object. Doesn't say anything more. Textbook of the medical with regard to the injury will only tell you only one line. Lacerated injury can be caused by a, I forgot, it's by a blunt object injury. So that can cause a lacerated injury. Cut injury is different. When you compare cut injury with a lacerated injury, then you will come to know that it is either caused by a sharp weapon and lacerated would be blunt weapon.
Now, page for a moment, page 74.
See,
Own
it doesn't
position and
say-
character.
Doesn't make, we can't go any further. I will tell you why. You see, it's in the occipital region. The injury is in the occipital region. He is hit by a handle of a axe, according to you.
That according to
no.
PW5.
No, it's okay. You are relying on PW5. It's assault by a handle of a axe. What type of injury would be caused? Please tell us. Occipital region, injury by handle of an axe. What, according to you, would be the injury? There would be some depression or compaction in the brain, occipital area of the brain. That's not there. It's only a mere lacerated injury. Size of the lacerated injury is not given.
Your lordship kindly peruse page 74, postmortem report.
We've seen that I am opening, I am holding page 74.
Point 2,
Yes. Lathi marks.
Latin. Then your lordship kindly come to
Now you
the
see lathi and handle of an axe.
skull healthy.
So therefore,
If X blow is there,
no, it's a blunt weapon. We can't say if it's only a
No,
lacerated
court,
injury.
while convicting, court relied upon PW 1 and 2.
No, we'll come to that. We have still now not read it. But you are asking in between, then we are saying that when it is a lacerated injury, it will only be caused by a blunt object. Blunt object may be handle of a axe. It may be a lathi. It may be a stick. Somewhere you have read that it was the lathi made out of betel nut. What did you say?
I am
No, you said that. What is that lathi of betel nut?
betel
betel
nut.
nut. So it can be anything.
I am trying to rest my case on 2 points. First, there is no, as per postmortem report, weapon is lathi mark. There is
Please tell us any authority on the point that
there is
non-seizure
no
of a
seizure
weapon
of there
no,
is
no.
no seizure of
Please
X.
tell us, is there any authority on the point that if a weapon of assault is not seized, then there is no murder?
Therefore, 2 views are possible, madam. When court in as many as cases it is said, when 2 views are possible. When 2 views are possible.
Let us take your view that no axe was seized, only lathi and spear.
No, I am not simply on that. I am trying to rest my case on 3-4 points. First, the witness, as per doctor evidence, who has conducted the postmortem, the time it was conducted the postmortem,
That
it,
we,
the dead body
we are
was
now,
48 hours.
we are now with this postmortem report regarding the injuries.
Yes,
Rest we are not closing. We'll hear you.
yes,
We're just trying to understand your point of view.
yes, that is my
You,
point.
you say that weapon seized was a betel nut
Betel nut.
lathi and a spear. Now, according to you, the injuries which are there, those does not reflect that a weapon in the nature of an axe or a dao was used. All right. For the sake of argument, let us accept that perhaps it was not used. The statement of the PW1 is also accepted that she had seen these people coming. Maybe they had brought it, but they may not have used it. But somebody must have used the lathi, which was seized.
On the basis of
That lathi, you see what injuries it has caused. Thorax, sternum fractured. What is sternum? Breastbone. This is a very strong bone. You can't just fracture a sternum with a blow or anything. It has to be a very, very hard blow. Then blood in the pleural cavity. Then larynx and trachea injured and collapsed. So it presupposes that there was a severe use of, let us say, a blunt weapon leading to the death. So even assuming the axe or a dao was never used, the death was caused by blunt weapon injuries.
on the
And a betel nut lathi of 2 feet, 2.5 feet was seized.
because this is not the case of the prosecution. This is not the case of the prosecution. Case of the prosecution is that the deceased was beaten by X and Dow.
That is their case, but evidence.
Therefore, on the basis of your lordship will aware the standard of proof in criminal case. In criminal case, my lord, beyond reason, all reasonable doubt, not simple reasonable doubt, beyond all reasonable doubt.
We
May or might be, my lord, on the basis
at
of
this
fact.
stage, we have not crossed that beyond reasonable.
Therefore, this is my humble submission. Is your lordship will be rising, my lord.
We'll take a break and come back.
Aye.
We'll analyze the evidence later. You just complete your part, then we'll analyze.
Yes.
Because it's very difficult once we have not seen the judgment, how the court has analyzed. So analysis prior to that is may not take us anywhere. In short, that is the point we are trying to tell you. We are just hearing the evidence, the nature of assault, the death, the circumstances. We don't even know. Are they anything on record to show that they are living in the tea garden area?
That part I have not found.
Gets map is there.
Appears to be so.
Yeah, appears to be so.
Yes, my lord. In the sketch map, it is the garden is there.
Garden is there.
Garden is there.
Has to be.
Garden is.
Has to be.
So my humble submission is that, my lord, evidence of PW file is corroborating with the, my lord, postmortem report. Because all injuries are fracture injury. There is no cut injury. And there are 1 and 2 clear cases that, my lord, assaulted with dao and axe. And that, my lord, also corroborated with the fact of seizure. Now, how the trial court dealt with, my lord, your lordship, kindly. Page 62 findings. paragraph 40. Now, from a meticulous scanning of the entire evidence on record, it discloses that on the fateful night of 25/5/14, the accused person, armed with dao, lathi, axe, and iron rod, entered into the house of the informant, dragged out her husband, that is deceased Tonkeshwar Gaur, and assaulted him with deadly weapons, causing serious injuries on head and body, and also assaulted the informant in her attempt to save the deceased and went away while the deceased succumbed to his injuries. The defense could not offer any cogent and satisfactory explanation as to how the deceased sustained injury on the head and body when evidence, ocular witness on record clearly indicate the presence of the accused person at the place of occurrence at the relevant time. In fact, there was no explanation at all from the accused person at the time of their examination under 313. The postmortem examination indicates that the deceased received 2 numbers of lacerated cut injury in the occipital region, with membranes ruptured and thorax, sternum fractured, as well as fracture at sternum, and doctor opined that all the injuries are antemortem in nature, caused within 24 hours, and cause of death is due to shock and hemorrhage as a result of sustaining injuries on body and head. The defense failed to demolish and discredit the prosecution witness in a cogent and convincing manner during the cross-examination to warrant a contrary interference in their favor. So the finding of the trial court recorded in paragraph 40 is wholly unsustainable. My humble submission is that. Because defense, it is not the duty of it is not the duty of the defense to prove that he is innocent. It is the prosecution to prove its case beyond all reasonable doubt. And right to remain silent in entire course of trial is a fundamental right as already held by this Honorable Apex Court. Your Lordship is well aware.
Just a moment. Original case.
Statement nine.
Nine. Payment one, this has. Yes.
So, my lord, there is no question of reverse burden because we have taken the plea of total denial. The appellant has taken the plea of total denial. So, therefore, the question of reverse burden will not come. And the trial court has held that the defense failed to, my lord, prove its case that they are innocent. Therefore, the finding of the trial court is wholly unsustainable in law.
Just a moment.
It is
In-
not exhibited. There is no inquiry.
But inquest was done.
Postmortem shows that inquest is there.
Ah.
There is something
No,
mentioned in the.
there, page 38 also, in the deposition of the IO, he says inquest was done.
Inquest was done. But exhibit, it is not exhibited. List of exhibition, your lordship will find it page page 65. Exhibit 1 FIR, 2 statement under 164, 2 Caesar list, 3 statement under 164, 3 postmortem report, 4 and 5 medical report, 6 sketch map, 7 chart sheet. No, this is 2.
How many accused are there? 2 or 4?
4 numbers.
4 numbers.
4 numbers.
Who were absolutely
To declare absconder. They never tested.
Oh. That is 3 and 4 are absconding.
Absconder declared.
18.
Jai Singh Gaur and Kamala Gaur. They are left now.
Dashin Gaur and Kamala Gaur absconder. And they are declared proclaim offender.
No, 45. This is GMT. At least follow.
So in summing up my submission, my the first, there is a defective investigation. The two column in the FIR left blank. Column number 8 regarding delay part, there are delay in lodging of FIR. So column 8 reason of delay left blank, and 11 inquest report. It is also left blank. There is no mention. Even if the inquest report was not exhibited, even then, if the evidence of PW 12 IO is accepted, chief, he says the inquest was conducted by OC Samaguri police station. That is not permissible under law. 174 categorically says OC must report the executive magistrate, nearest magistrate. 174. So this is also not, my lord, there are also a procedural law lapse, a great procedural lapse. 174 for a moment, your lordship. OC police officer cannot conduct inquest report, prepare inquest report. Police to inquire and report on suicide, etc. When the officer in charge of a police station or some other police officer is specifically empowered by the state government in that behalf, they receive information that a person has committed suicide or has been killed by another, or by an animal, or by machinery, or by an accident, or has died under circumstances raising a reasonable suspicion that some other person has committed an offense, he shall immediately give intimation thereof to the nearest executive magistrate empowered to hold inquest, and unless otherwise directed by the state, by any rule prescribed by the state government or by any general or special order of the district or subdivision magistrate, shall proceed to place where the body of such deceased person is, and there in the presence of two or more respectable inhabitants of the neighborhood, shall make investigation and draw up a report of the apparent cause of death, describing such wound, fracture, bruises, and other marks of injury as may be found on the body, and stating in what manner or by what weapon or instrument, if any, such marks appear to have been inflicted. So his evidence is OC Samaguri police station has conducted the inquest, prepared the inquest. So there is no inquest at all, my lord. This is my, because had there been an inquest as per law, it would have been, my lord, exhibited. That has not been done. And the next point is that, my lord, doctor's evidence shows that 48 hours. So my humble submission would be that, and that part has not been questioned by the prosecution. He remains as such. Therefore, his evidence goes to show that, my lord, the deceased was died much prior before the projected incident. And the evidence of PW Now I am relying upon some case laws, my lord. I will place it at a later stage after my friend is appearing in other case. I may be permitted to place it. Or may I now play?
It would be better.
My-
It's over the.
Video. First case law, my lord, I am relying on 2009 11 SCC 660. It is on 34 only. Paragraph 9. Relevant paragraph is paragraph 9. I am relying on paragraph 9. At page 3 of my compilation. Here my lord, conviction is 30234. Ingredients necessitated to convict, record conviction under 34 in aid of section 34 is absent. What is necessary, my lord? I am just reading my lord relevant.
No, I was stuck with your first submission. I've been a little out of touch with books, so therefore it took me some time to find it.
Medical jurisprudence.
I'll show you something. Orange flag.
Orange flag, ma'am.
You got it?
Yes, ma'am.
You show it to him also.
Yes, ma'am.
110, 3.
Yes.
All officers not below the rank of head constable have been empowered by the government under 174 to make an investigation on receiving information or an unnatural suspicion of unnatural of suspicious death.
So this inquest is covered by 174, and therefore anybody above head constable is empowered by the state. It does not say 1, 2, 3, 4, but it says 174. So
174, another aspects are also there. Investigation part, okay.
inquest is a part of investigation.
It is a part of investigation. They are the,
Empowered.
as a whole.
No, I
yeah.
don't know.
A person above the rank of constable, yes, he can.
I'm only reading it and telling you.
Yes,
I don't
this
know.
is Assam
This is-
policeman.
This is something. Well, I just remembered after a long time.
Shall immediately give intimation to thereof to the nearest executive magistrate.
I understand, but when there is an empowerment, you have to show that this empowerment does not cover inquest.
The report shall be signed by the police officer and other person, or by so many of them concur therein, and shall be forthwith forwarded to the district magistrate or sub-divisional magistrate when the case involves suicide. So
I don't know, because I don't know more than this, what I have shown you.
this is Assam Police Manual. This is Assam Police.
Assam Police Manual.
This
But
is a
law
part which
says-
they got to- no, I don't know. You see, I told you, this is the limit which I know. Beyond that, I do not. So if it is not there,
They
you'll
can't
have
have
to
the
perform the
power.
notification.
But the question is, the investigation, my lord, is where preparation of inquest report is not the whole investigation,
No, you
part
see,
of investigation.
we don't know. We don't know how to
Um,
break it up.
What
174.
I
how can we-
understand, I am expressing my view. Here the word as a whole investigation has been inserted. So my humble submission is, and my understanding is that, my lord, a police personnel above the rank of constable, yes, he can investigate the. That part I have no question. But the question is, while statute provided a categorical procedure, a specific procedure has been provided.
No, there also it says, you read that, somewhere in that provision also there is stated, empowered by the state.
He empowered by the state.
So empowered by the state can be anyone.
That part is absent because in cross we had to take this plea that
We
that
don't
was
do that.
not taken.
And this the first part is that this inquest report not being a part of the exhibits, we need not deliberate on that. It's not there. So it goes to your advantage.
So yes, it is defective.
And no, not defective. Because the inquest is there, in the case diary, inquest is there, and it shows assault. The inquest is there, available in the TCR, and it shows assault. The injury marks on the hand, the chest are available. So it goes
Yeah.
to your favor.
Yes, and I have the authority also. Our High Court the division bench judgment says, in absence of a benefit of doubt has been given. Inquest report. Inquest report not executed.
That's what we will see.
ऐसा नहीं कमा Rulership. Section 34, if such criminal act is done in furtherance of a common intention of the person who join in committing the crime, direct proof of common intention is seldom available. And therefore, such intention can only be inferred from the circumstance appearing from the proved fact of the case and the proved circumstances. In order to bring home the charge of common intention, the prosecution has to establish by evidence, whether direct or circumstantial, that there was a plan or meeting of mind of all the accused person to commit the offense for which they are charged with the aid of Section 34, be it prearranged or on the spur of moment, prearranged or on the spur of moment, but it must necessarily be before the commission of crime. So there is no evidence to that aspect. Section does not say common intention of all, nor does it say intention common to all. Under provision of 34, the essence of liability is to be found in existence of common intention, animating the accused, leading to the commission of a criminal act in furtherance of such intention. As a result of the application of principle enunciated in 34, when an accused is convicted under 302 read with 34, in law it means that the accused is liable for the act which caused death of the deceased in the same manner as if it was done by him alone. The provision is intended to meet a cause in which it may be difficult to distinguish between act of individual members of a party who act in furtherance of common intention of all or prove exactly what part was taken by each of them. So common intention not proved. May I proceed further? My next citation is, my lord, 2015-17 SCC 804. Page 5 of my compile. There are relevant paragraphs 12, 13, 14, and 15. As regards seized weapon, page 9, paragraph 12. We have perused the seizure memo prepared by the investigating officer, whereby the 3 weapons of offense were seized. So far as the farsa seized from the accused, Balbir, is concerned, we need not make any comment thereon, inasmuch as farsa is a generally known weapon in the structure, is a matter of common knowledge. However, so far as bollam are concerned, they have been described as jelly bollam in the seizure memos, as also in the evidence. Their description, especially of the sharp-edged head, is not given in the seizure memo. It is not clear if the head was a round sharp edge or a flat double edge. On seizure, the weapon were not referred to doctor for soliciting opinion if the injuries as sustained by Santara Devi would have been caused by the weapon which were seized as weapon of offense. Dr. Arvind appeared in the witness box. Then also neither the prosecutor nor the learned judge presiding over the trial took care to show the weapon to him and solicit opinion of Dr. Arvind whether the injuries suffered by Santara Devi could have been caused by any of the weapons exhibited in the court. So there is no material exhibition at all. The perusal of injuries sustained by Santara Devi as described by Arvind shows that on parietal region there are only 2 injuries, both incised wound. The other 2 injuries are abrasion, one on left side of cheek and the other on right forearm. Both are irregular in shape. The medical opinion as expressed before the trial court is that so far as these 2 injuries are concerned, they were likely to have been caused by fall on rough surface. Thus, we are left with only 2 injuries on the person of Santara Devi, which could have been caused by sharp-edged weapon. The medical opinion as elicited from Dr. Arvind whilst in the court is that the said injuries were likely to have been caused by sharp-edged weapon, like kulhari, that is an axe. The sharp edge of farsa is similar to sharp edge of an axe, and therefore the learned counsel for the appellant is right in submitting that if at all there was an assault on Santara Devi, probability lies more on the side of the 2 incised wound on the person of Devi having been caused by farsa, which is alleged to have been well dead by accused Balbi. In the fact and circumstance of the case, more so in the absence of medical opinion having been solicited either at the stage of investigation or during the trial, that two injuries on the person of Santara Devi could have been caused by Ballam seized from the accused Dinesh and Dayanand. It is difficult to hold that these injuries can be attributed to two appellant accused before us. This is over and above the fact that according to Jagdish, Bollam was used in trust way, in which case there should have been a punctured or penetrating hole rather than an incisive hole. The conclusion which follows from the absence of the testimony of Jagdish being corroborated by medical evidence is that either he did not witness the occurrence or the occurrence did not take place in the manner as narrated by the witness. In any case, according to his own statement, he was standing at a distance of 100 yards from the place of incident, and it is unlikely that he could have seen the minute detail of the alleged attack by the three accused, especially having regard to the fact that the time of incident, 5:30 p.m., was setting in the month of October, which will be almost the evening time when winter was setting in. There is no site plan available on record from which the court would have had an idea of distance between the place of occurrence, the place where Jagdish Ram Narayan are standing, and the situation of the house of accused person and the field. The incident where was the cause of the subsequent occurrence. We are surprised a little to note the manner in which the inconsistency between the eyewitness of the medical evidence has been dealt with by the trial court and the high court. The trial court by para 33 stated, it is possible that after receiving first blow from accused Balbir on her head, Santara Devi might have fallen down
Seventeen is for
has been considered a ground for acquittal. Paragraph relevant, my lord. 30, 31, 32, I am mostly reliable on this one. 31 and 32. Page 16 of my company. From the cross-examination of PW3, it's clear that evidence of PW 1, 2, 3, 7, and 8 are improvement over what they stated before the police under 161 CRPC. That too on material aspect. In their statement under 160, the narrative presented by the prosecution witness was that the deceased and subsequently the father were assaulted by stick. Before the court, this was grossly exaggerated to include assault by dao, spade, spear, etc. It was also stated in court that vein of the victim's hand and leg were cut by dao. The exaggerated version is not supported by medical evidence. When categorically ruled out assault by sharp and pointed out weapon, the injuries were sustained by blunt object and the death was caused due to coma resulting from injuries sustained in the head. In fact, 10 doctors categorically stated that the deceased sustained injury only by blunt object and there was no cut injury by any sharp weapon. We have already noticed that PW13 had visited the place of occurrence after more than 24 hours, and statements of many of the witnesses were recorded several days after the occurrence on such and such. Neither the dao nor the spade alleged to have been used in the assault of the deceased were seized. No sharp weapon like spear, etc. were seized. Even the stick or sticks by which the deceased was assaulted were not seized. That apart, the victim died on such and such, though the incident took place on such and such, after about 9 days of the incident. Therefore, what is discernible from the above is though there was certainly an assault by the accused person on the deceased, but the assault was carried out by blunt object. Therefore, it was converted into murder. Here, also in my case, the weapon of assault not seized. And in earlier citation, I have tried to project that it was not examined, or that DC only two weapons are seized, one is stick and another is rod. And postmortem report, I have not found, my lord, in the postmortem that there is a cut injury. But trial court held that the two cut injury. Postmortem report in what I have found that there is a fracture. Next, my lord, is page 18. My fourth citation is, it is a single bench judgment, only 2-3 paragraph I am relying upon, non-seizing of weapon.
You come to page 74. Skull vertebrae, two cut injury.
Lacerated.
But it is, you see, with the language you see, opitulated, two numbers of cut injury, lacerated.
Lacerated.
So cut injury is mentioned and then lacerated.
Therefore, my lord, 324.
That's okay.
324 and 326. Two sections are there.
No, that is,
Both are, my lord, punishment for cutting.
no, that is an interpretation.
Yes.
You said that it is not there. I just showed you it is there.
This is, of course, a single decision, my lord. Paragraph 29. Page 25.
Ah, yes.
The proof of charge, which is to be beyond reasonable doubt, must be depend upon judicial evaluation of totality of the evidence, oral and circumstantial, and not by isolated scrutiny. It is the settled principle of criminal jurisprudence that the view favorable to the accused should be adopted. It is also settled principle of criminal trial that equal treatment be given to the evidence of prosecution and defense. A strong suspicion cannot be the basis of conviction going by the requirement of proof of a criminal case. Then, skip my lord, paragraph 36, page 27. Apart from the fact that C's article, most importantly, the weapon allegedly used by the accused appellant was not produced. The signature of the accused appellant was also not obtained in the seizure list. No explanation is forthcoming as to why the signature of the accused appellant was not obtained in the seizure list. The accused appellant is also entitled to the benefit of doubt in absence of any site plan prepared by the police about which mention has been made above. Next, 38. In the case of such and such person, such and such, the apex court noticing that C's article, which could be the best evidence in the proof of claim of seizure, having not been produced and exhibited during the trial, was fatal to the prosecution case. In the instant case also, apart from non-production of the most important article, that is dao or knife, allegedly used by the accused appellant, coupled with the defense version that the injuries were sustained by the victim from sharp bamboo stick, make the prosecution weak. In the case of Kallikat Kunnu versus State of Kerala, reported such as such, eyewitness stated that the dagger was used to inflict injuries upon the deceased. However, apex court found that if that be so, the dagger could not have been enclosed in a sheath. It should have been found unsheathed and ought to have some bloods. This is not necessary. Only I am there 36 and 38 and 29. My next citation on delay of FIR. Page 5, it starts. Page 29. And I am relying upon paragraph 12. Page 36. FIR in a criminal case
a
and
moment, just a moment.
Mary.
Yeah, just a moment.
Page 36, no, para 12. The FIR in a criminal case, and particularly in a murder case, is a vital and valuable piece of evidence for the purpose of appreciating the evidence led at the trial. The object of insisting upon prompt lodging of FIR is to obtain the earliest information regarding the circumstance in which the crime was committed, including the name of the actual culprit and parts played by them, the weapon, if any, used, as also the name of the eyewitnesses, if any. Delay in lodging the FIR often results in embellishment, which is a creature of an afterthought. On account of delay, the FIR not only gets bereft of advantage of spontaneity, danger also creeps in of the introduction of a colored version or exaggerated story. With a view to determine whether the FIR was lodged at the time it is alleged to have been recorded, the court generally looks for certain external checks. One of the checks is the receipt of the copy of the FIR, called a special report in a murder case, by the local magistrate. If this report is received by magistrate late, it can give rise to an inference that the FIR was not lodged at the time it is alleged to have been recorded. Unless of course the prosecution can offer a satisfactory explanation for the delay in dispatching or receipt of the copy of the FIR by the local magistrate, prosecution has led no evidence at all in this behalf. The second external check, equally important in the sending of the copy of the FIR along with the dead body and its reference to the inquest report. Even though the inquest report prepared under 174 is aimed at serving a statutory function to lend credence to prosecution case, the detail of the FIR and the gist of statement recorded during inquest proceeding get reflected in the report. The absence of those details is indicative of the fact that the prosecution story was still in an embryo state and had not been given any shape, and that the FIR came to be recorded later on after due deliberation and consultation, and was then entitled to give it the color of a promptly lodged FIR. In our opinion, on account of the infirmities as noticed above, the FIR has lost its value and authenticity, and it appears to us that the same has been entitled and had not been recorded till the inquest proceeding were over at the spot by PWA. So there is no explanation. Explanation is required, but there is no any explanation as regard delay. And FIR was lost. Your Lordship, kindly note one thing. In the police outpost, not the concerned PS is about 12-13 kilometer, but the outpost is nearby there, within 2 kilometer distance of the place of occurrence. And that FIR was lost to the outpost, that too after 24 hours. And without no any explanation. Next citation is, my lord. This is also against delayed FIR, as I have already pointed out. Here, my lord, I am just going to read paragraph 15, 16, 19, and 20.
Look at the trial court record.
My lord, I need some time, lordship. Not to tell you, lordship.
Huh?
I have not gone through the same.
You
lordship. I need
go
some,
through it.
yes, lordship. Yes, yes.
Yes.
Next citation also on delayed FIR. So I am just referring the given paragraph
Yes.
15 and 16. Page 46.
Yes.
Here also, my lord, here after incident, he met the advocate, and then on the following day, FIR lost.
Here you want to say that the advocates are available in the police station.
Nowadays, my lord, this is I cannot deny because these are the facts.
Yeah, this-
Next, my lord, page 49, 2017, 13 SCC 98. Relevant paragraph is
Page 49.
page 49 will start.
Yes.
Relevant paragraph I am relying upon is paragraph 26.
This is also on delay.
Delay and lapse of the investigation. Paragraph 29, 26, page 58. Having gone through the evidence of the prosecution witness and the findings recorded by the High Court, we feel that the High Court has failed to understand the fact that the guilt of the accused has to be proved.
Just one, we are reading paragraph
Paragraph 26, page 58.
56.
Accused has to be proved beyond reasonable doubt. And this is a classic case where at each and every stage of the trial, there were lapses on the part of the investigating agency and the evidence of the witnesses is not trustworthy, which can never be a basis of conviction. The basic principle of criminal jurisprudence is that the accused is presumed to be innocent until his guilt is proved beyond reasonable doubt. So proof beyond reasonable doubt is necessary. Next paragraph, I am relying on 29. Even with regard to seizure of weapon, it was observed by the trial court that at one breath it was stated that the MOs were seized from the scene of offense, and another version was they were seized in the police station. And consistently, it was stated that MOs were not sealed, and the doctor observed that those were not sent her for opinion. That the immediate question which comes to the mind of the prudent person is whether the MOs which were before the court were the ones seized from the scene or offense. Hence, the adverse inference has to be drawn on the prosecution case. So here, my lord, chemical analysis, the material object seized, not sent for, already I have another citation I have. Here again also, my lord, there. It is not sent to doctor for chemical analysis.
Which one?
This judgment, this paragraph, it was dealt into that
Okay.
the material object that were seized, that was not sent to doctor for chemical, for opinion. That is chemical analysis. Therefore, it is the view of the prosecution rejected that the same weapon are used for committing the crime. And the doctor observed that those were not sent to her for opinion. Then the immediate question which comes to the mind of a prudent person is whether the MOs which are before the court were the ones seized from the scene of offense. Hence, an adverse inference has to be drawn on the prosecution case. That 33, next, my lord, I am relying paragraph 33. It is the duty of the court to consider the trustworthiness of evidence on record. As said by Bentham, witnesses are the eyes and ears of justice. In the fact on hand, we feel that the evidence of these witnesses is filled with discrepancies, contradictions, and improbable version, which draws us to the irresistible conclusion that the evidence of these witnesses cannot be basis convict the accused. Now, medical evidence 39, page 60. When we look at the medical evidence, the doctor has categorically stated the weapon were not sent to her. In the chief examination, it was stated that injuries 1 and 4 on the body of the deceased are possible with chopper and club. But in the cross-examination, it was deposed that even if a person fall on a sharp object, these injuries could happen. According to PW3, deceased fell into the drain. As per the evidence of the prosecution witness, the accused by using sharp-edged weapon assaulted on the right side of the forehead. But the doctor's evidence in this regard is that the deceased has not sustained incest on the forehead. PW 10 further stated that if a person is assaulted with an object like MO4, material object 4, it would result in fracture of frontal bone. Next 42. Once there is a clear contradiction between the medical and ocular evidence, coupled with severe contradiction in the oral evidence, clear laches in the investigation, then the benefit of doubt has to go to the accused. Here, my lord, I have already pointed out the contradiction in medical and the prosecution case as regard time of there. Next, page 62, my lord, previous enmity. 6, paragraph 6, page 63. The citation, mode of citation is 2023 0 Supreme SC 1135. Paragraph 6. Sri Chandrachud submit that on the basis of very same evidence, the learned trial judge has acquitted 4 accused persons. He further submitted though the evidence of PW 5, Ramkali and 6 has specifically attributed a gunshot to Uma.
Just a moment, Mr. Uddin.
Man,
This earlier judgment we cited may not entirely help you. The reason is different. The reason is that the trial court convicted the persons. High Court find inconsistency in the evidence and then convicted him. So therefore, in such cases, there is another principle which is applicable, which is the fact that in in a case of acquittal, there's something more which has to be looked into.
but
And in
should
this-
decide
in-
ND,
no,
it
no.
is applicable.
I'll tell you. In this case, PW1 and the evidence of PW1 and which is the ocular evidence and the medical evidence were at variance.
But-
That is the basic reason why the court went into that fact that he fell into a drain where the stones were there, and the suggestion that whether he could have died because use of chopper was not there. Correct.
I am trying to
No, that's one part. but-
substantiate my argument on the point that the time of that.
No, that's okay.
And here, my lord,
Yes.
ratio decide ND, the paragraph 42. If there is a contradiction, then benefit has to
goes
be
you.
given, my lord.
That's
This is the ratio decision. Therefore,
That's okay.
I am referring this.
yes.
Learned Counsel further submit that motive attributed previous enmity is so far fetches in much as the incident with regard to the murder of Ramdar, brother of Balaram, had taken place 4-5 years earlier. In any case, he submit that previous enmity is a double-edged weapon, and as such, the possibility of false implication cannot be ruled out. Next, I am relying paragraph 11. It is well settled as laid down in a locus classicus case of Bedivelu Tevar versus State of Madras, EIR 1957. There are 3 types of witnesses which are wholly reliable, wholly unreliable, neither wholly reliable nor wholly unreliable. The law laid down in Beduvelu Supra is consistently followed by this court in a catena of judgment. It can thus be seen that there are 3 types of witness. If the witness is wholly reliable, there is no difficulty in as much as relying on even the solitary testimony of such a witness, conviction could be based. Again, there is no difficulty if the case is wholly unreliable, witnesses in as much as which is partly reliable and partly unreliable, that the court face the difficulty. The court is required to separate the chaff from grain to find out the true genesis of the incident. So here, my lord, my humble submission is that the evidence of 1 and 2 are wholly unreliable. Because the unnatural behavior of these two witnesses. Next, I am relying on paragraph 17. As already discussed herein above, previous enmity is a double-edged weapon. We on the hand it provides the motive, where the other hand, the possibility of false implication cannot be ruled out. We find that the trial court has disbelieved the testimony of such and such as accused Umacharan was concerned. It could not have been applied a separate standard while considering the case of the present appellant, says Dhameshwar, Balram and Dhameshwar. So, previous enmity in the case, my lord, it is an admitted fact. So, rely upon this judgment. I am trying to project that there is every possibility for false implication. In as much as the already delay part is already there.
There must be some hint suggests the reason for false implication.
That is why Supreme Court says it is a double edge.
I know, but in the facts of this case, if the PW 1 and 2 has falsely implicated the accused, some hint somewhere, why?
Why I am basing upon 9, evidence of 9, doctor.
Hmm.
Because doctor says to 48 hours before, that occurred 48 hours before. And evidence shows that 24 hours before.
Okay, let me
So 24-hour gap, my lord. This
Let
is
me-
not,
let me put it across to you, what is in my
Yes.
mind. With permission. If it is a case that you had given a hint that it is not these accused, but PW 1, who because of whatever reason, there was a fight and the death occurred. There is no hint to suggest that PW 1 or 2 could actually have been involved leading to the murder of.
no, this is not there. Because they are wife and daughter.
That's right. So therefore, what is the basis to raise this doubt that they are
Enmity
falsely,
is there.
huh?
Enmity is there. It is an admitted fact. We are not in good terms. And what my humble submission is that, my lord, this part further strengthen, my lord. My argument is,
So therefore, it cuts both ways. It is not just PW 1 and 2, it is other witnesses who says, yes, previous enmity is there.
yes. They also, PW1 and 2 also admitted.
But then the question would be, what has happened to, what caused the death of the accused,
There
of
was-
the deceased? In
Yeah.
what manner?
That is the duty of the prosecution.
That's right. Obviously, the
pro-
prosecution
and-
cannot be expected to be present near about the site of place of occurrence. The investigation will only go when the
Yes.
event has already occurred.
Therefore, my lord, law permits, it is not, in all cases, it is not possible that eyewitness will be there in each and every case.
Right.
So circumstantial evidence. They are to,
No, this is more than circumstantial. 1 and 2,
1 and 2, my humble submission is, they are projected eyewitness. Because husband has been beaten and laying on a courtyard of the house, a wife would not under natural circumstances left him laying
for
on
the-
the courtyard and
Under-
stay whole
under-
night in a
under
nearby
threat of
house.
life, under threat of life possible.
Therefore, it's unnatural. Therefore,
Under threat of life, it is possible.
You see, there's no cross-examination.
no, there is no
There-
specific
there-
evidence that
No, there is deposition is, evidence is unshaken that they were threatened. They were grabbed.
they
and
were
threatened.
threatened in the they are, the threatening is up to that degree that when they rush to save the uh, life of the deceased,
That's right.
this threatening is not at gunpoint that you will be eliminated. This evidence is not there. This is my humble submission.
It's very difficult. These
The
are again,
degree of threatening, yes, if the
these
degree,
are not again matters of evidence. What extent the degree of threatening was there? Was it enough to chase away the lady to her neighbor's place, etc., etc.? These are not here. Fact is that there was threatening.
there was threatening only to the point that when they came to rescue him,
That's right. So therefore,
they were,
now, then you will have to go further and say what was the degree of threat imposed. It was not to that degree which would have caused any person normally to run away from that place. There is no evidence. to
maybe
that.
run away for time being, but staying whole night. 9:30, your lordship kindly note the time of occurrence. 9:30. On the following morning, they came to the place of occurrence. Whole night they stayed there.
And so therefore,
Yes, there may be because of threat, there may be for time being left the place. Or
Yes.
they could have the Keria, the person, the house of Keria, they took shelter in the house of Keria. Keria could have been sent.
they said no, nobody came, no neighbor came.
Keria is their relative. Neighbor is those people who are not relative of the deceased.
Then
Well, it doesn't take us anywhere because the accused is also relative.
Yes,
Then doesn't
one
take
of
us
the
anywhere.
accused is relative.
It doesn't take us anywhere. One is the relative, one is the son of the relative.
Here in this case, my lord, unnatural behavior of witnesses, my lord. Page 66, 2023, 0 Supreme SC 519. I am relying on paragraph 9, 10, 11, 15, and 19. Paragraph 9, page 68. In the instance case, when we examine the testimony of PW3, we notice him to have deposed that on the fateful night, around 11 p.m., both he and the deceased were sitting on a nala near the circuit house in Surendranagar. At that time, accused came on a motorcycle with Shailendra as a pillion rider, and after abusing wanted Ram, deceased, to state as to when he would return the money borrowed by him. When the deceased stood up to answer, Narendra pulled out a pistol and after placing it on the neck, said, "This would not take much time to finish you." Thereafter, accused fired the pistol. Resultantly, the deceased collapsed on the ground and started bleeding profusely from the neck. Immediately, Narendra, Jala, and Shailendra drove away towards the Sadar Society. PW3 stated that the incident left him shocked and stunned. He was so scared that he ran towards the society where he met his uncle PW9 and his friend Natwarlal Trivedi, whom he informed of the incident. Seeing his condition, he was asked by his uncle to go home and sleep. Next morning, he went to the house of Ram and narrated the incident to his mother and sister Hinaba Jala, Pradeep Singh Jala. Thereafter, he went to the hospital and informed Ram's father of the incident. Police interrogated him at different places and recorded his statement on 4th January at around 4:30 at the place police headquarters. Cross-examination part of the testimony reveals that witness to have repeatedly improvised his initial statement disclosed to the police. illustrative he had not informed the police having or on having disclosed the incident to the sister of the deceased. He had also not disclosed to the police that there was exchange of word between Ram and Narendra in relation to some money owed by the deceased to the accused. This may not have any effect on the veracity of the statement, but what makes his testimony shaky and witness unbelievable is his admission of the police headquarters being in cross to the place of occurrence of the incident, and despite knowledge that police is always posted at the gate, he did not approach the police. The explanation furnished is only that he was much scared, which prudently is not acceptable given that he was a close friend of the deceased. So, my lord, he went to home after witnessing the incident and went asleep on the sleep. Further, his credit stand impeached in the prosecution part in his testimony. Witness is an adult nature, mature and wholly worldly wise. He is 24 years and run a grocery shop. He is not illiterate. Yet he chose not to take any action, even to save the life of his friend. His explanation that he went home and slept in uninspiring in confidence for the incident took place in his presence and in his cross proximity habitation, more specifically at a short distance, that is just 3-4 minutes of walking distance from the police headquarters where constables are posted around the clock. He left his friend profusely bleeding on the spot but did not seek any help and immediately did not report the incident to the family member of the deceased. Whole house he visited only the following day at around 8 to 9 a.m. His conduct of going off to sleep, having seen his friend being murdered right before his eye and then not visiting the hospital forthwith is quite unnatural. Also, he did not inform the incident to his parent. It was only when the police interrogated him that he named the accused. His testimony is not free from embellishment, nor is not corroborated by any other evidence. Also, he admits not to have any information of any monetary transaction between the accused and the deceased. Here, my lord, friend, close friend, seeing his friend collapse. But in present case, my lord, husband went to another house and he stayed whole night. So, buttressing upon this, my lord, my humble submission would be that the evidence of 1 and 2, my lord, they are quite unnatural and therefore cannot be relied on. May not be relied on.
May not or cannot?
I am submitting, my lord.
That's what we are asking you.
Ought not to have been relied upon.
That is definitely a better way to submit.
My next, my lord, page 71. This citation, my lord, I am skipping because only one part I am page 75. Paragraph 5 and relevant portion page 75. Incongruity in the statement of the eyewitness and the medical evidence is vital, and the accused are entitled for acquittal. In Omar Singh versus State of Punjab and Ram Narayan Singh versus State of Punjab, to submit that, therefore, medical evidence, the contradiction, it is vital. Two other judgment, my lord, this is not compiled, I have on loose sheet, I have given it, my lord. Also on unnatural behavior. 2006 0 Supreme SC 634. It is there, my lord, in
The last case which you cited, do you know, why doesn't it help you? You want to know why your last case cited, it will not help you.
just contradiction part.
No, but actually you see what has happened. Come to paragraph 12, that is the answer. Line number 4. It is the case of the witness that Nirav PW3 met him in the hospital at around 9:30 a.m. and at that time informed him of the incident. This witness does not corroborate the testimony of Nirav PW3 of the disclosure of the incident either to his wife or daughter PW2. So you see the consequences is that PW3 informs PW1 in hospital who murdered. PW1 did not inform to his wife who is the murderer. Then next line says wife or daughter. Daughter is PW2. Further, the identity of the accused was known to both the PW1 and Nirav PW3, and therefore the statement comes subsequent in point of time at 4:30 in the evening. In the FIR, it is not there. So that is why the Supreme Court is dissecting the evidence to find out why it is not believable. And therefore, when PW3 says that he saw the murder and ran away, is doubted because of the fact that his statement
This
to the
is-
father
There are
is
several,
next day.
yes, there are several aspects has been taken into consideration. I have just citing one
That's
aspect.
okay.
The first part, that friend has been assaulted and a close friend, a intimate friend, he
No,
is
this is only to show you that what you are citing, we are reading it.
several part. I am just the portion, my lord, favoring me, I am
I
referring.
get it. I get it.
And another two judgment, my lord,
Hmm.
that is spread in loose sheet, my lord. This is not
Yes,
compiled.
it's
here.
there, it's there.
That is State of Maharashtra versus Raju Bhaskar Portfolio. Paragraph 6 and 7. Two paragraph I am reading. Several factors have been highlighted by the High Court to cast doubt on the veracity of PW2's evidence. Firstly, it is noted that his name was not indicated in the FIR. Furthermore, his conduct at the time of incident about what he did at that time corrodes the credibility of his version. He admitted that he did not inform the deceased that the accused was coming with knife, loudly proclaiming that he wanted to harm the deceased. Additionally, his conduct was quite unnatural because he did not take the deceased either to the hospital or police station and stated to have been gone to his home directly. Neither did he take him to the hospital, which was nearby, nor inform the police at the police station, which was also situated close by. The statement was also discrepant as to whether he returned from home after he had left the deceased in an injured condition. At one stage, he stated to have come after about 10 minutes, but in his cross-examination, he admitted that he did not return. Here also, same thing, my lord. He went home directly instead of taking the injured to the hospital or to the police station. Therefore, it was held that such behavior is unnatural.
Here also there is something which you should read. This case cited, you are citing this state of Maharashtra, Raju Bhaskar,
Yes,
correct?
yes.
You come to paragraph 2, at page 2, about 7-8 lines from the bottom. An offense was registered. You find it? An offense was registered against the accused at CR number so and so Jogeshwari Police Station on the basis of FIR. Sri Sharma, PW 12, took up investigation. He visited the hospital. He held the inquest on the dead body. I stop here. So here also, despite 174, there's a police who is doing it.
Yes. Police will,
No, I'm not evaluating it. I'm just telling you
Yes.
that this is happening. Despite
here
174,
my
this
humble
is happening.
submission would be, my lord. Magistrate duty is only to record the.
No, we are not assessing the.
Definitely,
We are
let us-
just telling you what you have seen. You see, this is a case of Bombay.
Yes,
They are much more, what you call, advanced in all respects than
yes.
than this small village where this happened. This Bombay is more advanced, but there also
Bombay crime branch
174.
is very famous in India.
But 174 is again sideline, and then the police takes up the inquest. And just on that, not the evidence of not the quality of evidence.
Next, paragraph 7, a learned counsel for the appellant submitted that he may have gone to inform the relatives. Interestingly, none of the relatives came near the spot. Injured was taken to the hospital by other. High Court found it unnatural that PW2 did not bother to provide medical assistance. He also did not inform the police. He claimed to have left his home. Whether he came back or not is another doubtful question, because as noted above, he himself admitted in court that he stayed at home. As rightly observed by High Court, it is quite unnatural conduct on the part of the close relative that he would leave the relative in a pool of blood, not bothering to take him to the hospital and not to return after having left the spot. Further, this conduct is not informing the police is another relevant factor. My humble submission, my lord, that it cannot be believed at all, my lord, that it is not at all believable that wife seeing husband falling down on the ground with severe injury, blood is coming out, will left the place for whole night. Exactly, this submission, my lord, my submission, I am trying to, my lord, buttress my submission on this, buttressing on this, my lord, case law. And another, my lord, is 2009-12 SCC 308. Here a small paragraph. Paragraphs number 6. It is to be noted that the conduct of the so-called eyewitness was absolutely unnatural. They did not make any effort to either save the deceased when he was being assaulted or when the accused person purportedly took away the dead body of the accused. Though in all cases the conduct of person would not be determinative, it would depend on several factors. In the present case, undoubtedly 4 persons who claim to have witnessed the occurrence did not make any effort to save the deceased from the assault made by the accused person was son of the deceased. The High Court noticed that the presence of the so-called eyewitness was practically not acceptable because of the various variations in the statement made during the investigation made in the court. The High Court found that the conduct was not only unnatural but also proved that their presence at the place of occurrence was doubtful. So, buttressing upon these two, and already I have earlier one citation, my humble submission is that the evidence of PW 1 and 2 is not acceptable, my lord, as per law, because they are wholly unreliable.
Okay.
And therefore, the last citation, my lord, on the inquest report, my lord. This is our High Court judgment, 2023, 0 Supreme Guwahati 789. Here, my lord, in paragraph 19, it is said, with regard to whether the appellant was the perpetrator of the crime, the evidence of PW3 point to the guilt of the appellant. Though the normal circumstance
Paragraph, you are reading which paragraph?
paragraph 19.
19.
Not
Yes.
with regard to whether the appellant was the perpetrator of the crime, the evidence of PW3 points to the guilt of the appellant. Though in a normal circumstance, we would not have much problem in believing the testimony of PW3, who is not only an eyewitness but the son of the appellant and the deceased. The discrepancy with regard to the date and time of death of the deceased, coupled with the fact that doctor who had in all probability attended upon the deceased in Dangtal Railway Hospital, Bongaigaon, and MJN Hospital, Kuch Bihar, not having been made prosecution witness. Besides, document not been exhibited by the prosecution gives rise to a suspicion as to whether the prosecution hide material fact from the trial court and this court. Next, I am relying on paragraph 25. On considering all above fact and discrepancies in the investigation conducted by the police and consequential prosecution of the case, we are of the view that respondent have intentionally hidden some fact from this court, thereby denying the learned trial court and this court the possibility of going into the truth of the matter. In that view of the matter, we are of the view that the conviction of the appellant cannot be based solely on the evidence of 3, who is son of the appellant and deceased. The reason being that though it was possible for PW3 to be tutored as he was only 9 years, living with 4, the pertinent question that arises as to whether the deceased had died due to being burned by fire. Next, paragraph 29. On perusing the postmortem examination report and the evidence given by the author of PW7, we are not convinced that burn injury suffered by deceased was the cause of death of the deceased. To ascertain the actual cause of death, material witness and documents such as doctor in Dongtal Railway Hospital, Bongaigaon Hospital, Kuch Bihar should have been made prosecution witness. Medical report, inquest report, documents referring the deceased to Kuch Bihar Hospital should have been made a part of the charge sheet and exhibited. Unfortunately, the same has not been done. So here also in this case, inquest report not exhibited. Unfortunately, the same has not been done. While the prosecution should be given all opportunity to prove relevant fact to enable the court to arrive conclusion with regard to the death of the deceased, the same principle would have to be followed to enable the appellant accused to prove his innocence. However, the investigating authority has by its Saudi investigation work not examined material witnesses and material document, and neither has it allowed the accused to do the same. And conclusion part is 35 paragraph. Here same thing, my lord. The exhibiting the document. This has been considered as fatal to the prosecution case and vital discrepancy. And therefore, my lord, benefit of doubt has been given. So rely on, my lord, all these case laws, my lord. And my humble submission is that, my lord, the prosecution is failed to prove its case beyond all reasonable doubt. And therefore, the present appellant before your lordship is maybe given the benefit of doubt, my lord. That's my humble submission.
Yes, Mr. Dhar, you have to add something.
My friend has already covered everything. Just 2-3 clarifications I will like to give. And first of all, if we go through the deposition of the PW1 once again, only I will page 13. Page 13. It starts with Anil Gaur, and Kamala Gaur is the wife of Anil Gaur. And the head of the husband with X. Joy Singh inserted the stick inside the mouth of my husband. That point I will point out, because Joy Singh was the person who inserted the stick inside the mouth, and that is why probably the post-mortem report also shows there are some inner hemorrhage and all these things. And this has been, same statement has been given by the daughter of the victim, PW2. Page 17, Joy Singh inserted a stick inside the mouth of my father, and Kamala dealt Tao blow on my father. So though the two eyewitnesses, both of them has said that a stick has been inserted inside the mouth of the victim.
Yes.
Rather than that, my lord, I would like to refer to the deposition of the medical
You
officer.
are appearing for this Anil Gaur.
Yeah, yes, my lord.
Anil Gaur.
Anil Gaur. I'm
And,
amicus for the.
Mr. appearing for Madan Panika.
Yes, ma'am.
The Joy is not a.
He's absconding,
He is absconding.
as well as Kamala,
As well as Kamala.
who happens to be your wife.
No,
His
Huh?
wife.
his wife, Madan Panika's wife.
No. 13,
So,
page 13. First line.
Kamala Gaur is the, yes, final, Anil, my wife. She anyway managed to. And Joy Singh is my son. Joy Singh is my son. My son and wife managed to live. Anyway, my lord, I am referring just like once again, because since my friend has already read out everything, the
So in short, you're trying to say that the offense by the family, here your role was only like a hen peck.
yes, it is my bad luck that I could not go with them, join my family. Well, at the medical officer's report, page 32, I'm just reading the opinion of the medical officer. In my opinion, the cause of death is due to shock and hemorrhage as a result of sustaining injury of body and head. And cross-examination, lacerated injury can be caused by blunt object. It has come up. And it corroborates at page 38. The
I think we'll have to rise because
My
the
lord.
bench, the single bench of my brother, we'll have to continue some other day.
It will take just 10-15 minutes from here. I'll just point out the missing part.
No, it's okay. Because there is a single bench. Pick it up. When is that matter? That Basically doesn't mean so.
You hand over the records?
Yes, my lord.
The court must.
May I please, your lordship? Lordship, for item 18, any date may be fixed. It's a habeas corpus matter.